So, you guys, I wanted to talk for a minute about writing because we really don't talk a lot about writing in these live streams. A lot of what I focus on is pretrial strategy and strategy once you get into the courtroom. One of the big parts of family law is the writing that goes into your case. And some of the writings that you do are definitely boilerplate, kind of standard forms and things like that. But other writing, really, you can use it to your advantage to help persuade the court in your case. For example, one of the most important writings in a case, in my opinion, is the pretrial statement. So before you have a hearing, probably a judge is going to require you to give that judge a summary of what you expect is going to be presented at trial. So in your pretrial statement, you're giving the judge a preview of what you intend to present. And you always have to check the rules and the laws in your jurisdiction, because there may be some jurisdictions where they don't allow you to get into argument in your pretrial statement when you're giving the preview. Other jurisdictions might kind of let you argue in your pretrial statement. So if it's possible, and if you're allowed to put information in support of your case in that pretrial statement, as opposed to just saying, I expect the evidence will show this, then, that's something you should consider doing. A lot of times, trial time is very limited and you were rushed. I know as an attorney, like in recent weeks, I've had 2 hearings. One was for a total of an hour. So that meant my client had half the time, which was half an hour to present her case. And then the other hearing was for half hour, which meant my client had 15 minutes to present his side of the case. So that meant we really had to go in depth and do good work on our pretrial statements and insert as much information as we possibly could. We really made it organized. So, the way that I organize my pretrial statements is according to the best interest factors. Now, wherever you are in your jurisdiction, a judge is going to say you need to provide a pretrial statement, and this is what the pretrial statement needs to include. You have to follow your orders. You always follow your court's orders in terms of what to put in the pretrial statement. For example, in Arizona, we usually have to list our witnesses, the exhibits that we intend to use, the uncontested issues and the contested issues. So the contested issues is your opportunity to go into what the evidence is going to present. And so when we get into contested issues and we're talking about custody or decision-making and parenting time, that's where I list out the best interest factors and really organize my statements according to each of the best interest factors that applies or that exists in my state. And the wonderful thing about a pretrial statement is that if it's very well written, then it can also serve as your outline for trial. And a lot of times that's what I use to create the script for my clients with the questions. And that helps me make sure that I'm addressing each of the issues that needs to be addressed. So pretrial statements are not the only important writing that you're going to have to do in the course of your case. There may be other motions to respond to. You may want to do a motion for temporary orders or some sort of emergency motion, or who knows, there are endless motions that you might have to do in your case. So a couple of tips that I want to give. One of what to do and one tip what not to do. So one thing that I learned in law school is that, the writing, your legal writing really needs to be persuasive. And the biggest takeaway I got from law school for making my writing persuasive is to use active verbs. So we have Tenacious Warrior on here who's a teacher. I don't know if you want to chime in and talk to everybody about active verbs. I had like some really strict grammar teachers growing up, like strict. So I'm kind of, I really get into grammar and punctuation and typographical errors. I tend to think I'm a pretty good writer. So an active verb is, instead of you're having your subject, the subject of your sentence is at the beginning of the sentence. So instead of saying, an example of an active verb or active use of verbs would be, I ran to the store, or Wendy ran to the store, or my client's wife questioned husband, instead of saying husband was questioned by wife. So what you're doing, I probably should have Googled this before I decided to talk about it. The person who is doing the thing should be the subject of your sentence, and you're active verbs instead of making the person who did the thing part of the predicate. So use active verbs wherever you can. Descriptive verbs, I use the thesaurus a lot. So instead of just saying, for example, the word said, I would Google it and find out what other words I could use instead of the word said to make it just more colorful and vibrant and interesting and persuasive for the court. So that's number one. Use active verbs wherever you can to make your writing more persuasive. So the second thing, and this is a really big thing that is very important, and that is, you guys, only state in your motions things that you know to be true. Don't guess about the other side or things that the other side may or may not have done. Don't name call in your motions. Don't call the other side a liar. And it may be true. Maybe they are a liar, but that's your job to prove that they're a liar in the courtroom. But don't put that. Okay, so Tenacious Warrior, thank you, is chiming in on what active and passive verbs are. So an active verb is the subject of the verb. Does that make sense, you guys? It is the doer of the verb, the person or the thing who's doing. So, but when you're writing your motions, you guys, don't name call. Don't accuse somebody of being a criminal or selling drugs. Okay, so for example, the defendant yelled at me in front of my kid. Those are examples of active verb use, and it makes your writing much more persuasive. The judge is the one reading, so you want to make it as persuasive as possible. You guys, don't accuse unless you have convictions proving that somebody's committed a crime or that somebody's a drug dealer, or that somebody's a sex offender. Don't accuse them of doing these things in your motions. And if you're writing a pretrial statement and you think you're going to be able to prove that somebody was dishonest, you can say that you expect the evidence to show X, Y, Z. But, just don't flat out lie about somebody or make something up without having a good faith basis, because that really could come back to bite you. It's not very professional, and, just don't do it. Stick to the facts. Keep emotion out of it as much as possible. I know you're very emotional about your cases, but I think a judge will find you more credible if you take the emotion out and really just stick to what you're going to be able to show.